Hey everyone, welcome back to the channel. Today we've got one of the most nonsense judges completely shutting down a defendant who seriously thought it was a good idea to represent himself. Spoiler alert, it wasn't. Huge thanks to Colin for catching this live stream and sharing it so I could bring it to you. Before we dive in, a quick word about today's sponsor, Aura. Every month we hear about a new data breach. Last December, Bank of America left sensitive client documents in an unsealed container, exposing names, account details, social security numbers, and more. That data could have been on the dark web for months before anyone even knew. And the average company takes 277 days to report a breach. That's why I use Aura. They notify me instantly if my info shows up on the dark web or if someone tries to open accounts using my data. They even offer $5 million in identity theft insurance. Protect yourself at aura.com/teamskeptic and get your 2-week free trial. Now, let's jump into the video.
All right, this is case number 24 CR 137, State of Ohio versus Brian Keith Taylor. Are you Brian Keith Taylor appearing there from the jail?
Yes, sir. Yes, Your Honor.
All right.
Just
a minute. We have to be quiet. This is case number 24 CR 137, State of Ohio versus Brian Keith Taylor. This is a pretrial being conducted by Zoom. The defendant's been indicted on 3 counts of aggravated trafficking and 3 counts of aggravated possession of methamphetamine. Mr. Taylor's attorney is Dennis Kirk, appearing from his office, appearing from the prosecutor's office, Prosecutor Collins. This is a final pretrial. I believe we have a trial date set for April the 7th. Now, I believe that discovery was filed. There's no, Mr. Kirk, did you file a compliance with discovery?
I did, Your Honor.
Okay. Well, we pulled these files last week, so we, actually I see over here there's a red jacket. I see them. Yeah, okay. And then it looks like the state filed an additional discovery this morning with a lab report on it. And you received that?
I did receive that. Yes, my client's not yet aware of it, but I will take that out to him.
All right. And I don't see any pretrial motions filed, or did you file any?
I did not. I did not see the warrant for any, so I did not file any.
All right. Now, what's the status of the case then in terms, I know we have a trial set on the April 7th, so that's actually inside the 14-day window, but I believe that this was the best we could do on the scheduling date. So what's the situation here with this case, counsel?
It's protection.
I have made my client aware of his plea offer. We did actually negotiate on that. I have made him aware of the 14-day rule. Also, the form to basically I forget what the technical term for it is, but basically the plea refusal form, gone over that with him as well. He does not wish to sign that form, but has not necessarily stated he wants a jury trial either. He did want me to go back to the state with some additional things, which I did, and they declined to change the offer. So at this point in time, I'm not sure what he wants to do. He's never given me a clear answer.
It's tough to get a straight answer from someone who sounds like they've been chewing on crayons instead of thinking clearly.
So, Mr. Taylor, are you rejecting the plea offer the state made and electing to go to trial? Is that your decision?
The process, this process here, this pretrial hearing, I got motions. I'd like to file.
Well, you're not representing yourself. You have an attorney. And so,
I know that.
Wait a minute. Just wait a minute. I'm going to address this. And under the rule, motions, if you have an attorney, only your attorney can file a motion. So if you prepare something that you want to file, I have ordered our clerk's office not to accept those. They will not accept them because you are not representing yourself. The only way you can file a motion is if you represent yourself, in which case that would be a huge mistake. And you haven't asked for that, and there's be quiet, don't interrupt me when I'm speaking. I'll give you the chance to talk. You just be patient, listen, okay? One of your problems may be that you want to speak instead of listen, and that's a big mistake too. So, getting back to my point is that, there's not what's called a hybrid representation system in Ohio, and that's a criminal case. The defendants can't file their own motions. Now, your attorney's indicated that he has reviewed these with you and didn't find anything that had any legal merit, arguable merit that he could file. And under the rules of law, attorneys aren't permitted to file frivolous motions just because their clients think they should. They're the attorneys. They're the ones that know the law. They're the ones that know the rules of professional conduct. They're the ones that are bound by it, not a defendant who wants to file any kind of number of motions based probably on what you've seen on TV or in the movies, which is, again, a real big mistake to believe that kind of crap. So that's where we're at. Now, going back to my question, are you rejecting the plea offer?
Yep.
Yes? Okay, then we will have a trial on April the 7th. All right, so does the state expect this to take more than 1 day?
No, the state expects us to be finished in 1 day.
Okay. And you agree with that, Mr. Kirk?
I would agree with that, and I would note just for the record, I've been given no names, addresses, phone numbers of any witnesses, so I don't think we'll have very many, if no witnesses at all.
Well, if there's going to be any witnesses, Mr. Taylor, you have to give those to your attorney so that he can file and respond. Those will due by today, so if you've got them, get it to him right away so he can give them to the state. I'll give you till tomorrow to do that. Now, anything else that we need to discuss in this case?
Yeah, I'm going to ask to have my attorney removed, and I got grounds here. I asked him to file a few motions which are legitimate. I mean, this ain't from TV, this is from going through the law book and studying day in and day out. Everything I got the case numbers, case laws, I got.
Motion, what kind of motions are you talking about, Mr. Taylor?
Well, one is a motion to suppress. One is, and I got one here, it's a
motion to suppress, but this is I believe this is a undercover buy situation, isn't it?
It is 3 buys.
Okay, so I don't know what kind of motion to suppress would be appropriate. What do you think could be suppressed?
It'd be.
Well, if you know so much about the law, you should be able to answer that question.
Maybe he'd answer better if the question came shaped like a crack rock. But since we're using regular English, and he's missing his daily fix, the brain just isn't connecting the dots.
I've got an attorney here who knows the law and tells me there's no basis. And now I've got you telling me there is, and I ask you what it is, and you can't tell me.
I asked you to file his motion, and
I know that. I'm saying is, what is it you think should be suppressed and why? What's the legal basis for it that you, being a non-lawyer, has come up with that an accomplished lawyer has not?
That's on my paperwork here. None of you organized here at the same time.
So you have an answer. What is it you would seek to suppress?
I don't know.
Pardon me?
I don't know.
You don't know? Okay. Anything else you want to bring up?
I'd like to have my attorney move from the case and have another one, please.
Wait a minute, I'm having trouble understanding. I can hear you.
I like to remove my attorney and get another one.
Okay, well, you have until April 7th to get yourself a new attorney. If you want to get a new attorney, you can do that. You'll have to hire them because you didn't hire Mr. Kirk. You didn't have the money to hire an attorney, so I appointed him for you. So, he's your attorney unless you get a new attorney. But if you do, they need to be ready to go to trial on April the 7th.
I can't get another court-appointed attorney. I can't afford an attorney.
No, you have a court-appointed attorney. I've given you a court-appointed attorney.
But he's not representing me.
Yeah, he is. He's representing you, and he's had conversations with you and discussions. You don't like what he's telling you. I get that. If I were in your position, unless they were telling me you're going to walk free and the state's going to give you a written apology and $1 million, I wouldn't be happy either. But, he's not going to do that. So, unless you can tell me why he is not, he shouldn't be your attorney, then you've given me no reason other than the fact that you don't like what he's saying and he won't file motions that aren't proper, which is no attorney would file. So getting you a new attorney would not mean anything because a new attorney wouldn't be able to file frivolous motions either. And if I gave you any attorney who knows what they're doing, they're not going to do anything different than Mr. Kirk is. Mr. Kirk's been doing this a long time. Now, anything else you want to bring up?
Yes, I have grounds. mean, I haven't.
I asked you what your grounds were, and you didn't tell me anything. You said you didn't know on suppression.
I'm trying to be respectful. Wait till you're done talking.
I'm sorry, what?
Trying to be respectful, man. Wait till you're done talking. You got only once for interrupting.
Okay. I asked you to answer my question, and you didn't when I asked you what your grounds were. Now, I'm not going to give you another attorney. If you want to get a new attorney, that's up to you. You feel free to do that. You'll have to hire that attorney. But I don't know who told you that you're entitled to get more than one attorney because the court has appointed you an attorney. Mr. Kirk is qualified and competent and experienced and knows way more than you'll ever know about the law. So just because you've been in court a few times doesn't mean you know anything about the law. Just because you got a book you can read doesn't mean you know anything about the law. I could read a book on brain surgery, but that wouldn't make me a brain surgeon. You can read a book on the law, and it doesn't make you a lawyer.
Where has this judge been all my life? I'm glad Colin found him, because judges like this who actually call things like they see them are rare. Right now, he sees a wannabe genius without the genius part.
Now, any other things you want to bring up, Mr. Taylor?
Represent myself.
Well, that would be the biggest mistake you've ever made in your entire life. Based upon what you've been telling me, I don't think there's any way in the world you could represent yourself. Pardon me?
I haven't been able to tell you nothing.
I can't understand your mumbling.
I haven't been able to tell you anything.
Well, you're not the attorney. You're on trial. You don't get to participate in your defense because that's what an attorney is for. That's why you have one.
But am I allowed to have a fair and just defense?
Oh, absolutely, and that's what you're going to get. We'll have a fair trial. We'll have a jury, and we'll have a trial.
I don't have all my discovery. I'm missing 12 things that I'm undiscovered. I'm begging for.
Well, he's got the discovery. Well, let me explain here, Mr. Taylor. I met with your attorney and the prosecutors before this hearing, and he kind of outlined to me some of the things you're talking about. As I understand it, you have everything of any importance. I think he said you had mentioned that you didn't have a copy of the resume of the BCI analyst or something, which is minor. It doesn't mean much. He can get that to you. He will get that to you. But the other things that you want, my understanding, he's given you more than what most defendants get in these kind of cases because usually there's a counsel-only discovery restriction. But since the identity of the CI is known, apparently they have let you watch the videos, right? You've watched the videos of what they say are the buys, right? And you've gotten copies of everything that he has, pretty much. Is that correct, Mr. Kirk?
That is correct, yes.
All right. So I don't know what you're talking about when you say you don't have discovery because you've got everything that he's got.
Sure, he's got all the papers a lawyer would have, but unfortunately, he's missing two key things: a law degree and his freedom.
And that's it. Discovery is what he's giving you what he has.
My discoveries don't even have counsel eyes only stamped on them.
It doesn't have to have a stamp on it. It's done by email.
And at the same time, I get a piece. I get a piece 1 week. I get a piece 2 weeks later, and I get a piece Monday.
All right. Well, good. It gives you something to do. So what? We still got 10 or 12 days to try. But again, you're not going to be the one that's going to be questioning the witnesses and presenting evidence and making arguments. That's what your attorney does. Pardon me?
Well, I'm afraid of.
I would be afraid too if I were on trial, but that's not why we're here. This is a final pretrial, and we're ready to go to trial. The court, we're going to send out our jury notices today. State's ready to go, and you're going to be ready to go unless you get a new attorney. And again, you're not going to get maybe you can find somebody to be willing to take the case and go to trial on the 7th. But that's going to be on you. If you want another attorney, you can get one. But all this stuff you're telling me doesn't amount to a hill of beans, as my dad would say.
I represent myself.
Pardon me?
I represent myself.
Well, if you want to do that, how are you going to do that? What do you know about the law?
I don't know that much about the law.
And so you want to go to trial not knowing much about the law against a prosecutor that does know the law?
Percentages would be higher, yes.
Pardon me?
I think I would have, my percentages would be higher, yes.
Well, I can't understand what he's saying.
He
Yeah,
said his percentage would be higher. His percentage of winning would be higher if he.
Oh yeah, what do you think that would be?
I don't know.
Well, give me the odds. I'll take that bet. Because you're absolutely 100% wrong. You know, everything you're saying here is exposing the stupidity of your position. And for me to allow you to represent yourself will be guaranteeing you a conviction. You'd be convicted of everything. You don't know what you're talking about.
This guy's facing real time, and he still can't put together a basic defense. Somehow, he thinks this mess is improving his odds. At this point, just hand him the rope, show him a tree, and let him play hangman. Solo.
Have you ever picked, do you know what the word voir dire means? Okay. Yeah, do you know what the separation of witnesses is?
That's one of my motions to seven.
Well, we don't get, no, separation of witnesses, I ask you.
Yes, yes.
Okay. So what is it?
Motion to ask 5.
Huh?
Motion to ask him to 5.
Okay, well, that is filed at the time of the trial. When we start the trial, that's an oral motion. What kind of a motion did you want him to file?
You have to give me time to get it.
No, you're the one that claims to know more than he does. You should have been prepared to tell me. If you've got all these arguments, you know, don't tell me you got to sit there and try to figure this out, because we're not going to sit here all afternoon. You tell me what it is you wanted him to file. You just told me you wanted him to file something. Tell me what it is you wanted him to file. Don't tell me you got to go look for it.
I'm pretty organized here.
Well, why can't you answer the question then?
Because I can't tell you without.
Okay, well, look at it. You should be able to find it. I'll give you 15 seconds. Find it.
File a motion for the rest of my discovery.
There is no other discovery to file. Again, you cannot. Pardon me?
I got a list here.
What?
I think he's basing his list off of other
No,
people.
I'm not.
Because he thinks there's a set number. Sir, he thinks
Listen, be quiet. Let me hear what Mr. Kirk's saying. Go ahead.
He thinks there's a set number of discovery items. I've told him that is a myth. Some people may have 14. Some people may have 2. And I've explained that to him. However, he does not trust my advice on that. I do not believe he's missing anything other than there is a lab report that was just filed that I will be taking out to him. But he thinks there's some sort of mythical set number of items.
Okay.
Judge, I can probably shed some light on this as well.
Go ahead. No, would like to.
Some defendants believe that they should have copies of the buy money, for example. In this particular defendant's case, those are actually pictures that were on the digital evidence that he would not have access to out there because he's in jail.
Right, I understand.
There are several things that are digital evidence that he physically cannot have access to because he's in jail.
Okay. Well, your attorney has those, and he's shown them to you, as I understand it, right?
Yes, he showed me the digital stuff, but he has showed me, yes, right. But also, if they're going to have PCI experts on the stand, and we get a chance to cross-examine them, shouldn't I have their qualifications and all that for cross-examination? Also,
Cross-examination would be based upon their report.
Also, the submission report to the BCI lab I don't have, and I don't have the physical evidence or the witness. I got the witness list. I don't have the CI's felony report. I don't have the forfeitures. I don't have disclosure of all evidence and everything from them.
Well, your attorney has it, and he has it, and he's discussed it with you. You don't have to have all that with you in jail. I don't know that you'd have room for it. Ms.
That doesn't exist.
Pardon me?
A lot of this that he's talking, so he just said he doesn't have a list of the forfeitures. There are no forfeitures in this case.
Oh,
he
well,
has
there would
the
be. Yeah.
CI's. He has the CI's criminal history. He just doesn't know how to read the discovery.
Honestly, you could have stopped at the word read. I'd be surprised if he could even read the label on a salt shaker at this point.
We provide the CI's.
Okay. So-
CA
Right here, John. Right here, my bill particulars, right? Correct? This right here is a signed paper that's the end of my particulars. That right there, my daughter needed a commission slip to go to school. I can put this on it. Nothing there says that goes to a bill particulars. There's no date, no stamp, no nothing on my bill particulars.
All right, well, I don't really, it really doesn't matter. It's immaterial. You have copies of what is filed, and that's what's important.
I can answer this too.
Legal process.
All right, wait a minute.
I can answer this too. We don't file a bill of particulars in court because it names so much protected information.
Right.
We file a notice of filing. The
Right.
bill of particulars doesn't get stamped or anything like that. It's secret.
I understand, but it still has to have some type, something on, because it can be reproduced. Everything I got can be.
Okay, well, again, you're operating from a complete ignorance of what's going on here. As she indicated, the bill of particulars does not have to be filed with a file stamp in the public file. And in fact, oftentimes it's not, because it names people that are to be remain confidential. And in some cases, we've had a situation where the paper picks it up and prints it all before the trial, and then that person had all that information is out there that could potentially prejudice the defendant. And so your complaint about it not being file stamped, it means nothing. That is a big fat zero that means nothing. You have a copy of it, and that's all you need.
Criminal Rule 16C says that it has to be prominently stamped, counsel eyes only. And everything they gave me.
Well, it's not stamped cancel eyes only. You've got everything in this case. Now, I'm not going to argue with you anymore. All right? The bottom line is, what you're saying is all without any legal merit whatsoever, because you've read a book and you think these things say this and that, and they don't. And you're not entitled to stuff that doesn't exist. You don't have to have stuff that doesn't have to be file stamped, and nothing that you've told me means has any legal significance at all. It seems to me that what you ought to be doing is focus on the allegations in this case and the evidence that you do have in this case, which is apparently some videos or audios and witness statements and people who are going to testify. That's the stuff you need to be focusing on, not on a whole bunch of stuff that you think you should get that you're not, that either one doesn't exist or two is you have it and you don't understand it, and that's your fault. And that's just, again, the fact that you don't know what you're talking about. That means
everything.
Pardon me?
I brought so much to my lawyer, and he has dismissed and excused that. I got this form smoking crack in the video, but he dismisses it and justifies it. It says I'm smoking a pipe, and nowhere in the video I'm smoking a pipe, but he dismisses it and justifies it.
I'm not fluent in whatever dialect of Pillbilly he's speaking, but here's what I do know. If I were him, I'd take the free lawyer and hope they could shave off some years instead of making things worse.
Well, it'll be in the trial. I mean, if whatever the videos show, they show. I don't know what's on there. This isn't about that. We're not going to argue about that. Whatever the evidence shows will be what is going to be introduced at trial if we're going to have a trial. And it sounds like that's what you want. So if you want to have a trial, that is completely fine. We're going to go ahead and send out a jury notice here this afternoon, and we'll summons in the jurors, and we will see you on April the 7th. Again, if you want to represent yourself, again, I would tell you that would be a big mistake. But if you want to file that motion, I will have a hearing on it and give you the opportunity. But I can tell you that you will absolutely have no chance in the world at a trial based upon your performance here today. Because just because you represent yourself doesn't mean you get to bring up everything that your attorney says you can't. Because if he says you can't do it, and he's right, which I'm guessing that he is, because he's been around the block a few times and tried cases in this court, then you're not going to be able to bring it up. And so when you're being upset with him not bringing up stuff you want him to, when he tells you you can't, it's not admissible, that's going to be the ruling of the court. And most likely what will happen is you're going to come in here thinking you can do this and that, and you can't, and I won't let you. You'll end up hardly having anything to say on your own behalf. You're not the first person I've dealt with that's represented themselves, or wants to represent themselves. And, if you want to do that, you can file a motion. There's a hearing I'll have to go through and ask you a whole bunch of questions that will point out, what a big mistake that is. You'll still have to have a legal advisor to stand by to answer questions for you at the trial. They won't be able to participate. And we won't start the trial, you representing yourself and then deciding, coming to your senses and finally realizing you've made a big mistake and then say, okay, Mr. Kirk, I'm in over my head, take over. That's not the way it works. Once you start it, you're going to finish it. Again, under the law, unfortunately, the court is not permitted to protect the biggest right that a defendant ought to have, which is the right not to be stupid. Unfortunately, you do have the right to be stupid, and you can exercise that at any time. And if you exercise that by representing yourself, that will be the biggest mistake you've ever made.
Your Honor, I think his biggest mistake was developing a weird obsession with superglue. But maybe I'm biased because I have a glue intolerance.
I'm just telling you that. I can tell right now that you're not going to be able to effectively represent yourself. But if you want to, once we go, just be quiet, I'm explaining. If you want to file that motion, that's one motion I'll permit you to file on your own. We'll have a hearing on that, and we'll go through all those requirements I'm going to have to do. I'm done with you now because I've got other cases I need to move on to. This is a pre-trial, not a trial, and I'll make that ruling. And so if you want to do that, I'll have a hearing on that, maybe Monday, and that'll give, and we'll see what's going to happen. Again, I'm telling you, do not try to represent yourself. And because, when you said your odds will be better, they'll be infinitesimally worse. They'll be so much, so bad that you can't even imagine it. And again, these cases, in cases like this where, you need to focus on what the evidence is as opposed to what you think the attorney is or isn't doing. That's the issue. Look at the evidence that you do have. What is the evidence against you that the state says they're going to present? And then make your decision based upon that. And as far as asking for stuff that's not out there, or stuff that you can't have in jail because it's digital, and your attorney has shown you those things, you have everything that the state has. There's nothing more they can give you. And so, you could file 135,000 motions asking for more discovery. If there's nothing more to give you, they're not going to be granted, So, what you're asking for is stuff that you apparently think you know about that you don't. And again, I don't know where you come up with these 14 items of discovery, but to the extent that you're getting advice from people that are in jail, think about, how smart they are if they're where you are.
You say I'm getting my ideas from everywhere else. Every idea I'm getting is coming from the Criminal Handbook 2018, and everything comes out of it that I've got.
You've got everything you're supposed to get. That means the criminal law book doesn't create things. It just tells you what you're entitled to. The state has provided all that. Your attorney has got it. He has shown you everything, other than this last lab report, which just came in, and he's going to give that to you. He just got it today. So, you have it. There's nothing that you are entitled to have or can have that you don't have. So, I don't know. I don't know what else to say. So, all right. Now, we're done. Anything else from counsel?
No, Your Honor.
All right.
No, you're right.
All right. Thank you.
That's it for the video. He had a hearing scheduled for early April, but we won't have to wait. Colin just messaged me. The guy pled guilty to 2 counts of aggravated meth trafficking and got sentenced to 6 years in prison. If you liked the video, smash that like button. If not, feel free to hit dislike. Drop your thoughts in the comments, and don't forget to subscribe with notifications on. Thanks again to Aura for sponsoring. I'm Team Skeptic, and I'm out.